Director Psychological Operations, Commandant OCDS, Senior Officers, ladies and gentlemen, good afternoon. It's my great pleasure to address this, present this presentation to this audience, and thank you. My gratitude goes to the Commandant and also the Chief Instructor giving me this opportunity to conduct the lecture. The rule of law by itself is not a law. Rather, it is about the rule of law denoting the level of practice of rule of law and existence in states, whether they are big or small. Hence, it is stressed that in every country, rule of law, the legal system should be clear, well understood, and fully fairly enforced, upholding equality for every citizen, irrespective of creed, breed, complexion, strength, power, or status. The law speaks about human rights, fundamental rights, civil law, criminal procedure, and enforcement of contracts, so on and so forth. It is considered that rule of law is a bedrock for democratic civil societies where democracy cannot exist without the rule of law. All the contributing governing organs in a state, namely executive, judiciary, and legislature, should act collaboratively but independently in exercising or practicing rule of law. Thereby, rule of law becomes the cornerstone of every democratic society where all citizens must be subjected to the law. The country law should be all-inclusive and comprehensive, where exercising or implementation of law, where law should be effective, incorporating the entire spectrum of rule of law as applicable. All government officials and all private citizens must follow rule of law of the state and must be treated sensing the fairness, adjudicated under the law. The government interference cannot be accepted because it is the very reason that the government is created by and for the people, and it is answerable to the people. This deep study on the history of the rule of law presents ample evidence as it had been emanating over thousands of years in history. The best example is religions that had been the sources, and later rule of law was strengthened with contributions of scholars as denoted below. Gentlemen, if you watch carefully, the above indicates the sources, that is Buddhism, Christianity, Islam, and Judaism, and where Judaism had been the oldest among all religions. It is about more than 3,000 years. Then when it comes to Buddhism, it is 2,500 odd years, and Christianity is 2,015 years, and the Islam it is 1,470 years. And all the other sources indicated below are especially during the Greek, related to the Greek and the Roman history. Since then, its mechanism of governance being influenced by the religion in different magnitudes. By scaling pros and cons of religion-based influence, international community today introduced improvements to the rule of law as a priority, especially to uplift human rights. The rule of law existence differentiate from state to another, irrespective of whether developing or developed. Nevertheless, success factor of improvement and strengthening rule of law remains mixed, modest, and hard to measure. In the world, apart from governing bodies, there are legal organizations for promoting collaborative justice, which seem a joint effort, that is, a part of the governments. The organizations are military of a state becomes a key constituent upholding rule of law, irrespective of status, whether officer or soldier has a responsibility by rightly understanding the sphere of duties to uphold the rule of law. With that, aim of the presentation is as shown on the screen. The sequence of the presentation is as shown. There are several scholarly definitions to rule of law, and it is important to examine few. The first, the second definition, ladies and gentlemen, with these definitions, I presume that you have a clear understanding of what is rule of law. Having learned the definition of rule of law, it is important to know different contexts of rule of law. In that, there are three, that is, rule according to law, rule under law, rule according to higher law. Firstly, we will see rule according to the law. The rule of law requires the government to exercise its power in accordance with well-established and clearly written rules, regulations, and legal principles, which is ruled according to the law. A distinction is sometimes drawn between power, will, and force. On the other hand, it is the law of the country. When a government official acts pursuant to an expressed provision of a written law, it is acting within the rule of law. But when a government official acts without the imprimatur of any law, it is considered sheer force of personal will and power. Under the rule of law, no person may be prosecuted for an act that is not punishable by law. When the judicial organ of the country to punish someone for an offence that was not deemed criminal at the time it was committed, the rule of law is violated because the government exceeds its legal authority to punish. Next, it It is the rule under law. The rule of law also requires the government to exercise its authority under the law. This requirement is sometimes explained with the phrase, "No one is above the law." During the 17th century, however, the English monarch was vested with absolute sovereignty, including the prerogative to disregard laws passed by the House of Commons and ignore rulings made by the House of Lords. In the 18th century, absolute sovereignty was transferred from the British monarchy to the Parliament, an event that was not lost on the colonists who precipitated the American Revolution and created the US Constitution. Next, it is ruled according to higher law. A challenge is posed when the government acts in strict accordance with well-established and clearly defined legal rules and still procedures, a result that many observers consider unfair or unjust. Before the Civil War, for example, African Americans were systematically deprived of their freedom by carefully written codes that prescribed the rules and regulations between the master and the slave. Even though these slave codes were often detailed, unambiguous, and made known to the public, government enforcement of them produced negative results. Do such laws comport with the rule of law? In some countries, the political leaders assert that the rule of law has no substantive content. These leaders argue that a government may deprive its citizens of fundamental liberties so long as it does so pursuant to a duly enacted law. At the Nuremberg trials, some of the political, military and industrial leaders of Nazi Germany unsuccessfully advanced this argument as a defense to plead charges that they had committed were horrible crimes against European Jews and the minorities during World War II. Now let's see rule of law stakeholders. The following components of the society are the stakeholders of rule of law. As I said at the very beginning, every institution is subjected to the rule of law of the country. Now with this we will go to see principles of rule of law. The principles of the rule of law being the basis of exercising and practicing rule of law irrespective of states that are developed or underdeveloped, as I mentioned previously. There are 4 principles, and they are: in most developing societies, the rule of law is still under improvement or construction, and it is found that the level of rule of law has a significant impact on economic growth and human development. The rule of law is effectively imposed that society being supreme as no one, no politician, no government, no judge, no union, no citizen is above the law. Everyone is subjected and privileged to enjoy benefits of the law. It is also important to know how we assist in the present conflicts of the world. Rule of law existing or practiced in the world today is based on certain criteria. The measuring based on following criteria, annually covering all the countries existing in the world. In that, following assessment criteria is used. All these criteria are incorporating all the organs of the governance, that is executive, judiciary and legislature, where enormous powers of the absolute power, if it is practicing, that is again checked under these criteria. It is also important to have an idea on the level of rule of law in countries in the world, which is indicated below. Gentlemen, now I here try to compare and also give an overview of the present situation based on the world justice system. Now, when it comes to the first one, it is the earlier we used to call first world. Now it's not that generally used, but still, all these countries, Denmark becomes the first, and next is the third world countries where Sri Lanka position, and here we have got 58th position, where India is 59, likewise. And also next is the comparison with 3 continents. Australia separately, and Argentina and Colombia, South America, where they rank 54th and 62, where you can have some idea on this, where Sri Lanka is 58th in that case. And South Africa 36, and Burkina Faso, a Central African country, is 78. And again, since the rule of law was broken during the Arab Spring, you can see 2 countries, that is the Arab Spring started, Tunisia, that ranks 43rd, and Egypt 86th. Public security is a function of the governments that ensures the protection of citizens, organizations and institutions against threats to their well-being and to the prosperity of their communities. Hence, whether it is war or peace, officers and soldiers owe the military shoulders a greater stake as constituent stakeholders in exercising and maintaining rule of law. Even though the fact remains same, any action by a soldier or an officer in the field, if it is detrimental to rule of law, could reflect in the highest forum in the country, that is Parliament. In the context of fast communication influenced by social media, nothing could be hidden or prevent leaking, tarnishing the image of the government and the military. The officers and soldiers' responsibility in peace remain very important. It is a readiness for action once called upon, as it cannot be predicted the date, time, or the need in moment for authorities to call upon military for duties. As an example, if the government call armed forces for duties under Public Security Ordinance of 1947, their president as head of the state and the commander-in-chief has the power to declare a state of emergency and enact emergency regulations. The president also has the power to call out armed forces in times of emergency, riots, etc. under the Army Act, Section 19, Navy Act and Air Force Acts. The examples are, you must have heard about 1958 Sinhala Tamil communal riots, where this was imposed, and again during 1971, during the insurrection, it was enacted. 1958 riots prompted the government to incorporate an important amendment to call out armed forces during emergencies, and armed forces so called out acquire police powers except investigation powers. Under Section 2 of Public Security Ordinance, the President can declare a state of emergency that include following situations. Under Section 5(1) states, this is self-explanatory. It is in the interest of the public security and maintaining the public order or during mutiny or riotous commotion. Same, section 5(2) states, under these regulations, it is possible to detention of persons, and in that there are two instances: taking of possessions of any property or undertaking, acquisition of any property other than land, entering and search of any premises allowed. Emergency regulations are enacted to regulate following: creation of offences and punishments, arrest, detention, control of information, that is censorship, creation of restricted zones, disposal of bodies, and regulating the operations of various organizations, that is NGOs, as an example. Under Part 3, Section 12(1) and 2, the President may hold armed forces. Here it's very important to remember, it is a situation where authorities decide that police is not in a position to control the developed situation or the existing situation. It is also important to remember clauses under section 12(2). Next we will see the other clauses under section 14(1). Now here remember, it will not be exercised by any member of the armed forces of a rank below that of a sergeant. In the army or air force it is sergeant again and petty officer in the Navy. During peacetime, that is when there is no state of emergency or where the armed forces are not called under public security ordinance, Part 3, the army does not have any power to perform law enforcement duties. In peacetime, the power of the army is restricted to the following: this is very important to remember. Now we are enjoying peace or fragile peace or whatever called. Now anyway, the emergency regulations are not enough, and these are the powers that we have. Also we will see powers to disperse unlawful assembly. Now here you have to read very carefully. Right. Next, it is empirical situations on rule of law highlighting consequences. The situation depicted are based on practical incidents that has taken place in the past, which deem very important for you to understand the role, responsibility, and the framework that you can performing duties. Let us take the incident of Ratu Baswala that took place in 2013. In this incident, the army was supposedly called on to duties and it bounced back, tarnishing the image of the army and internationally the government and the country as a whole. What happened? Finally, police said that they didn't call army to the scene. Please see the incident denoted in this slide.